Good morning, good afternoon, and as I've been reminded, good evening to everyone. I'd like to thank the attendees for being present. I'm Les Schiefelbein, and I'm the Chief Executive Officer of the Silicon Valley Arbitration and Mediation Center. And I must say that Silicon Valley is very excited to again be a part of a program during Paris Arbitration Week. This actually is one of my favorite programs, not just for the affiliation with the arbitration community, but this is the only Silicon Valley program I know of where we have doubled the attendance in size for every year we've had the program. So Alex Blumrose, I would anticipate 5 years from now, you'll have to reserve an auditorium or some palace in Paris. If we're doing this in person. But some thank yous. I'd like to thank Bill Seward, who does administrative work for Silicon Valley. Bill put this all together. I'd like to thank our panel members, and Alex will introduce them in turn. But what the panel does today is it brings together two of the very important things that Silicon Valley brings to the international arbitration and mediation community. The first panel today will focus on, experts in technology arbitration, best practices in common law and civil law. And we'll focus on an efficiency point in the international arbitration and mediation. And then to go to the end of the program today, Congrita Leao will introduce a very new initiative we have, which we're really stepping out of our comfort zone a bit. And we're having an initiative on using blockchain-based technologies in international arbitration and mediation. So we're transitioning and linking both the practice and process points to add value to technology-based alternative dispute resolution. And that's what Silicon Valley's about. So I just wanted to say hello, introduce myself, tell you a little bit about the program and the exciting initiatives we have. And I'd like to turn to Alex Blumrose, who is Paris-based. And Alex will guide you through the program, introducing the panel. And he will be the master of ceremonies this morning, as it may be. Alex?
Great, thank you, Les. Hello, everyone. As Les said, good morning, good afternoon, good evening. Thank you for joining us. We are very proud and happy to present this program from Paris and from around the world. You can see my background is not my home, nor is it my office. This is the library of the Paris Bar Council, the Paris Bar Association. And so this is to remind us that we do have a link to Paris. We have a link to Paris Arbitration Week, and we are a part of it. So even though we can't travel, or many of us can't, maybe by this picture, we can be reminded that this is indeed Paris. So I'd also like to say a couple of thanks. Thanks, Les and Bill and the others at SVAMC for taking the initiative and renewing this program here in Paris during Paris Arbitration Week. This is our 3rd year of doing this program. And this year, and I'd also like to thank our other association co-sponsor, which is the AFDIT, AFDIT, that's the French Computer Law Association. And we have a member of their board who will be speaking on our moderated panel a little bit later on. I'm very excited to hear this panel about experts. I'm especially excited because finding the facts is the preliminary step to finding the law. And whether you're a counsel or especially if you're arbitrator, this is what we need to do to get to the final award, the binding award, which is what the mission is. I'd say almost the sole mission, the prime directive as an arbitrator. To get to that final award, you need to get the facts, you need to get the law. And how do you get the facts? You can rely on the parties, and they can have their experts, and they can contribute to the proceedings with technical and other information and data that will be left to the assessment of the arbitration panel. But there may be other ways, using tribunal appointed experts, for example, to bring information and that assessment to the tribunal about the facts in the case. And what we're going to do today with our panelists is drill down to see how arbitrators in a technical dispute, like a technology dispute about whether it's about blockchain, it could be any kind of technology dispute, data privacy, management of data, how experts can bring their expertise to the arbitration panel to get to an efficient and a just decision. So this issue of experts for the arbitration panel is doubly interesting for our technology practice. A number of the panelists are on the SVAMC tech list. Krengutta is on the list. Les is on the list. I'm on the list, and we have over 50 technology arbitrators who specialize in technology arbitration who are on the tech list, and they are faced when they are sitting in an arbitration matter with not only having to address the facts and the law, but bringing to the arbitration and arbitrator experience a certain amount of knowledge. Often they are selected as arbitrators because they have a technical expertise in the technology industry. And so you have, in effect, experts overseeing experts. And how does that work? Does that add a layer of complication or challenge? When you have technology expert arbitrators, are the criteria for having recourse to other experts, outside experts, different? What should a tribunal consider in a technology arbitration, depending on the configuration of the parties, the posture of the case, the expertise of the arbitrators? What should the tribunal consider before having a recourse to outside expertise to help them assess the facts? So I'm very excited about this. I have been involved in a number of cases where these issues have been presented, including with some of our panelists. And so I'm very excited to see what our discussion will become. So I will be, as Les said, your master of ceremonies during the next 2 hours of this panel. We have divided the panel into several parts, 4 parts to be exact. We have an opening presentation by Alina Leavino from Mayor Brown. Then that will be followed by a panel discussion that will be moderated by Stan Putter of Conway and Partners in the Netherlands. Then after that panel, we will have a presentation by Krengutta Leao and of the LDDP firm. And after Krengutta's presentation, we will have a question and answer session of about half an hour to 45 minutes, where we will take questions. Now, I would ask that you think about questions and that you keep your questions in abeyance, as they say, until the end. Now, you can raise your questions if you have them as we go along using the Q&A button on your screen. And we will address all of the questions at the very end of the panel during that fourth part of the presentation, which is the Q&A session. So with that, let me introduce our first panelist, Alina Leviano. Alina is a senior legal consultant in the international arbitration practice at Mayer Brown here in the Paris office. She specializes in commercial arbitrations and commercial disputes. Before joining Mayer Brown, Alina was at the ICC, first as a deputy counsel for the Central and Eastern European team at the ICC Secretariat. But her last mandate, and this is maybe the most interesting part, or a very interesting part for us today, is that she was the manager of the ICC International Center for ADR, and responsible for ICC's ADR services, which include mediation, dispute board proceedings, and expert proceedings. And so I would just say a word as part of that introduction, that the expert proceedings that the International Center at the ICC provides includes, and this is from the ICC website, 3 distinct services which Alina will tell us about, including the proposal of experts and neutrals, appointment of experts and neutrals, and the administration of expert proceedings. And so with that, let me turn the mic over to Alina, and then I will come back to bother you again as your MC later on when she is done to introduce the later sessions of this panel. Thank you.
Excellent. Thank you very much, Alexander. Thank you, Les, for having me. Good morning, good afternoon. Hello, everyone. We're absolutely delighted to have you with us this afternoon in Paris, even though it's only virtual this time. But hopefully for the next sessions, we will be able to see each other and meet in a proper conference room. So today's discussion, we decided to start it with a presentation of the ICC expert rules and the procedure, because you know, Alexander already asked the right question by asking the audience and us on the panel, what should the arbitral tribunal consider before having a recourse to the outside expertise? But may I dare to say, where should the tribunal look for the experts, and where should the tribunal take those experts from when they actually, when they're needed? In a normal case scenario, I guess any of us would have its own network, we'll call friends, you know, thanks to conferences as Paris Arbitration Week, we get in touch with many people, so we end up meeting very interesting profiles, people with very interesting profiles. But when we've exhausted all our means and we still haven't found the perfect expert, what do we do? What do tribunals do? So my proposal for you this afternoon is to look at the ICC International Center for ADR and to, you know, and let's see how they function. How do they propose, appoint, or administer expert proceedings? All right, let's go to the first slide. Many of you would be familiar with the ICC International Court of Arbitration and with the arbitration services, which are being administered and provided by the ICC. But the ICC has 2 dispute resolution players. The court, together with the secretariat, they administer the arbitration rules. And then the second player is the ICC International Center for ADR. Alexander already mentioned it. The center administers these 4 types of procedures, which you see on your screen. The mediation rules, the expert rules, the dispute board rules, and the doc-dex rules. We'll be looking today at the expert rules. But before we start, let me give you an idea about what type of cases the center usually receives. On the second slide, you will see that the majority of cases administered by the center are mediation cases. Expertise comes second as a service among the 4 which are being administered by the center. The ICC International Center for Technical Expertise was established in 1976. It became later the ICC International Center for Expertise, and now it is being known as the ICC International Center for ADR. The current rules are in force since the 1st of February 2015, and to my knowledge, I don't have the exact number, but from what I remember, the ICC Center has administered already 670 cases, expertise proceedings. On slide 3, and as Alexander already mentioned, you will see that we have 3 types of services which are being proposed by the center. The proposal of expert, the appointment of expert, and the administration of expert proceedings. So let's take a look at how, you know, when a party, when a tribunal, when a lawyer is calling the center, how do they look for these candidates? The selection of experts, how is it being handled by the center? Well, the center, first of all, there's no closed list. Many of you, and I actually encourage you to get in contact with the center. You would, you know, very often ask this question, whether there is a list and how can I get on that list? Well, the center does not work with lists, but the center uses its network of national committees, of course, its own contacts, but also the contacts of the Standing Committee of Experts. And what is this Standing Committee of Experts on slide 4? Well, this Standing Committee of Experts is more or less the equivalent of the International Court of Arbitration for arbitration. So it will be the Standing Committee who will actually take the decision of a proposal or appointment or a scrutiny of an expert report once it has been drafted and prepared by the center. So the final decision really lies with the Standing Committee of Experts. Now, you will not be surprised that the typical qualification of the expert, when parties come to the center and request the proposal appointment of an expert, well, obviously they're looking for a specific background, usually different language skills. It's rarely English, usually it's a different language, field of activity, nationality, independence, and experience. Now, let me say a few words about, on the next slide, on slide 5, let me say a few words about the proposal of experts. Well, this is a proposal. Like the name suggests, it's not binding. It will be, anybody can ask for this proposal from the center, anybody paying a $5,000 filing fee, $5,000 filing fee. But really, you do not need to have a tribunal asking for it. You do not need to have any party, any legal entity, any physical person could ask for the proposal of an expert. On slide 6, you will see very briefly how the procedure is being handled by the center. The center usually receives a request for a proposal in which the person or the legal entity details the requirements for the proposal. The center will start looking for the ideal candidate, will launch a research with the network of the national committee, and then will really propose such an expert to the Standing Committee of Experts, which in turn will either ask for more questions or will simply ask the center to look better if the candidate does not fill all the criteria requested by the parties. And if it becomes really impossible to find that person, it's envisageable that the center can appoint perhaps a team of experts instead of one. All right. So the role of the Standing Committee is really, we're on slide 7, excellent. The role of the Standing Committee is to assist the center in reviewing the attributes of the expert and has the final decision on the proposal. Regarding the costs, well, there's a filing fee of $5,000. The rules do provide for an additional filing fee of $5,000, but from my experience, this provision has been rarely used. So usually a filing fee of $5,000 is more than enough to cover the work of the center. Arbitral tribunals in the pending ICC cases may request the proposal of an expert from the ICC International Center for ADR for free. And, you know, while this is definitely increasing the work of the center, this possibility has been very much used by the arbitral tribunals, who can even, you know, have a chat with secretariat at the center and explain what the case is about, and then request a proposal of the expert. And again, it's being done for free. Appointment. Regarding the second service that the center provides under the ICC expert rules, well, this is the appointment of the experts and neutrals. This time the situation is a bit different, because whereas the proposal was not binding, where here the appointment is binding, because in most of those cases, actually in all of these cases, there is a clause in the contract which provides for the appointment of the expert by the ICC. If you want, the ICC really acts as an appointing authority in this specific case. Just like for the proposal, the request can be submitted by any person, a physical person, a legal person, and the center can appoint as expert a physical person or a legal entity. In those booklets that you see, you know, you see them on my presentation, you'll find also all sorts of clauses, model clauses, which have been prepared by the ICC to be used by the parties when they want to insert such a clause, so that the ICC acts as appointing authority. Now, the procedure is more or less very similar. On slide 9, you will see the details of such procedures. So the procedure is more or less similar with the ones for the proposal of experts. Applicants will simply file a request detailing the the requirements they would like the potential candidate to comply with. And the center will again launch a search for candidates within the network of national committees, with the Standing Committee of Experts and its contact itself. And what's really interesting as well, and I think it's important, and it proves important, the tribunals have told the center that it's really important for them, is that not only does the center look for the criteria and the qualifications requested by the parties, but the center will also invite the candidate to fill in statement of acceptance, availability, independence, and impartiality, so that any potential conflict of interest or any disclosures the expert would like to make is being made at the very outset of the proceedings. And depending, of course, of the type of disclosure the expert makes, the center will decide whether to put it in place or not. The filing fee is the same, it's $5,000, with the possibility of requesting an additional fee, but just like for the proposal, I've rarely seen this being applied. It's really only in those very specific cases in which we kind of looking for la perle rare, really, somebody who should fulfill so many criteria that it's almost impossible to find. So this is when the center could appoint not just a person, but a team of experts. Now, regarding the third service on slide 11, which is the administration of expert proceedings. Now, for those of you familiar with the administration of arbitration proceedings, this will sound very much similar with it, because the role of the center is more or less the same with the role of the secretariat when administering arbitration proceedings. So what is the role of the center when it administers an expert proceedings from the very beginning to the very end? Well, first of all, it receives a request, right? Then it proceeds with the appointment of the expert, which of course it's binding. Or if the party is jointly nominated, of course it will confirm such a joint nomination. The center will coordinate between the parties and the expert. It will scrutinize the this is being made, it's not really in the rules, it's more made on an informal basis, but the center will scrutinize the expert's mission before it's being done, discussed with the parties, the terms of reference or the expert's mission, supervises the financial aspects of the proceedings, and that is a relief when you compare it to ad hoc proceedings. That's a true relief to have an institution taking care of this aspect. And also scrutinizing the expert's report and before it's being notified to the parties. So once it has gone through the scrutiny process, the center and the standing committee of experts then proceed with the notification to the report to the parties. On slide 12, I included two main provisions, Article 5 and Article 6. Now, Article 5 deals with the location and the language of the expert proceedings. So the expert determines the location and the language as a preliminary matter and separately from the expert's mission. The center usually encourages the expert to do that, as soon as it receives a file from the center. Article 6, it's really one of these key provisions of the rules because it deals with the decision on the scope of the expert's mandate. I've seen many cases in which the parties did not necessarily agree on the scope of the expert's mandate, and it's really at this moment in time that the experts needs to decide on the scope of the expert's mandate in the event of a disagreement between the parties. And really, from my experience, it happened quite often. On slide 13, we continue with the procedural steps. So the expert is required to prepare a procedural timetable, to give each party the opportunity to comment on any information or documents provided by any other party. It does happen that sometimes there are non-participating parties, and it's not because a party is not participating that it deprives the expert of the power to make findings and render the expert's report, provided, of course, that such a party has been given the opportunity to participate. And for this type of service as well, just like for the other ones, proposal and appointment, the ICC has included in its booklet model clauses, which I invite you to look at in case you need them. Now, the draft of the expert report, once it's being received by the center. Now, what does the center do? Well, first of all, it verifies that the report is reasoned because the expert report must give reason for the findings. So most of the times, a typical comment from the center would be, can you please elaborate on this point? It's not clear. The expert reports are not binding unless the parties expressly agree in writing that the findings shall be contractually binding. And in many of the experts reports I've seen at the center, I would say that in most of the cases, this provision was there and the parties did provide in writing for the findings to be contractually binding. And regarding the admissibility of the report, yes, it shall be admissible in any judicial or arbitral proceedings between the same parties unless otherwise agreed. This is Article 8.3 of the rules. So once the expert report is being submitted in draft format, the center can provide direct modification as to the form. I insist on that because the center will never be able to modify the result of such an expert report. So when the center does a scrutiny of the report, really it will look at the form of the report and draw the expert's attention to the points of substance. But the ultimate decision regarding the issues which have been included in the report will obviously be the experts and not the centers, not the ICC. Here as well, just like for the proposal and appointment of experts, the center is assisted by the members of the standing committee in the scrutiny process. I really encourage you, if you're curious, you can go check the ICC websites because the members of the Standing Committee of Experts are listed on the ICC website. The president of the Standing Committee, it's James Nicholson from FTI Consulting. So do go ahead and check out the profiles they have included on the website because I think it would be interesting to see the type of profiles of the standing committee members, which will be looking at these reports. And once the expert report, so, you know, imagine there is, so the draft expert report is being sent to the center provides its comments on the draft expert report. There is some exchange of correspondence between the center and the expert, and once the draft has been finalized, it will be signed and ultimately notified to the parties by the center. It sounds like, you know, this step could actually take a little bit of time, but in practice, it's not, it doesn't take longer than, I would say, 2 weeks to 3 weeks, not more than that, between the receipt of the draft of the expert report until the notification to the parties. All right, let's move on. On page 16, you will see that contrary to the previous two services that we mentioned, the proposal and the appointment of experts, here things are a bit different. Indeed, the parties are requested to pay a filing fee of $5,000, but then depending on the length of the proceedings and depending on the complexity of the proceedings, the ICC will request and fix an administrative fee, which would include, in addition to which it will include the experts' fees and expenses, and then the total amount, it's really the equivalent of the advance on costs in arbitration, would be shared by the parties in equal shares. All right, so these are the three services which the center proposes. So proposal, appointment, and administration of expert proceedings. We should now look at so on slide 17, I pulled out some statistics. They do date from 2018, but I received in the meantime the 2019 ones from the ICC, so I would be very happy to fill you with the new numbers. So take a look at the economic sectors. You will see that construction comes on top, and it was 32% in 2018, and it's still on the top of the chart in the 2019 as well. Construction sector is followed by the industrial equipment, energy, chemicals. Other is a bit of everything. So it would be very difficult for me to explain what's in there, but it's really, and otherwise, all sorts of sectors. But those three, it's very interesting to notice that these three sectors, construction, industrial equipment, and energy, are more or less the same as the sectors, the economic sectors involved in ICC cases during the same period. On the next slide, on slide 18, you will see the statistics concerning the origin of the parties regarding the ICC expertise in 2018, but in 2018 it's more or less the same thing. For example, in 2018, parties coming originated from Europe, 37%, and the ones in 2019, 49%. So actually this percentage has increased, has slightly increased. Europe is followed by the Americas, 34%, and Asia and Africa will come last. On slide 19, I included some statistics regarding the parties which are using the expert services. You remember that I was mentioning at the very beginning of the presentation that it is mostly the parties which request the proposal appointment of the expert, followed by ICC Arbitral Tribunal, and then there's a small number of cases in which there are other arbitral tribunals, so not necessarily ICC, it can be DIS or any other, or maybe why not ad hoc arbitral tribunals requesting for proposal or appointment of experts. We move on, and then we have another graphic basically telling us how many, which is the most successful of the three services proposed by the ICC, and it's really the proposal, which of course is non-binding and it's easier to access, and administration comes last, administration of expert proceedings. So Alexander, this is what I have prepared for you. I'm more than happy to take questions either now or perhaps towards the end of our discussion. during the Q&A session.
Perfect. Wonderful. Thank you, Alina, for that very clear presentation about the center. We're going to move on now, and we'll take the questions during the Q&A. We'll move on now to the panel discussion, which follows immediately from what you've just described, because I noticed in the geographic allocation, there's quite a bit of European use of the expert proceedings that you just described. And one of the issues that our panel is going to discuss is the common law, civil law divide, if you will, the difference in approach between those two legal cultures in connection with the use of experts. I've been, despite my New York City accent, I have been practicing law now in Paris for 30 years, and I've seen in practice the great difference that there is between the US approach with party-appointed, party-selected experts, often two or more experts who confront each other, and then the arbitral tribunal has to decide, and the civil law approach, which we have in France, which I think Stan probably has in the Netherlands, where it is quite easy, as Yves, our French expert, will describe under Article 145 of the French Code of Civil Procedure, to go to the court and have the court appoint an expert who will then carry out an expertise proceeding and inform the court, the parties, the judge, or an arbitral tribunal. And so this is going to be a fabulous discussion. I will let Stan Putter, who is the moderator, explain more about what they are going to do and introduce his panelists. Stan is a Dutch lawyer who is specialized in dispute resolution and also advisory practice, primarily focused on international arbitration and proceedings before Dutch courts in matters having international issues. He has quite a bit of experience in arbitrations before the ICC or under the ICC rules, LCIA rules, NAI rules, and SCC, the Stockholm Center rules. And Stan is also affiliated with our sponsor, the Silicon Valley Arbitration and Mediation Center, as he is on the membership committee. So I will turn it over to Stan for the panel.
Alex, thank you very much. First of all, I think a big thanks to you is in place because you have done pretty much a bit of the heavy lifting to getting this session together. So I don't want to refrain from commenting on that. So thank you very much, Alex. Thank you also to everybody in the audience. There were quite a bit of different tasks to do today. We all have work to do. You could have chosen to also attend the GAR Awards digital session today, or the Informa conference, or as one of the audience members, Artem, has done, speak on the Informa conference and now be here. So thank you very much for taking the time to be with us this afternoon. Right, yeah, the panel session is already somewhat introduced by Alex. We're going to discuss the various angles on technical experts in international arbitration, of course. We have an interesting panel here with 3 panel members who have various perspectives on these issues. We will be reviewing the situation both from a counsel perspective, an arbitrator perspective, and we're very happy that a frequently appointed tech expert is also here with us. Let me first introduce them to you before we head off with an interactive Q&A session with them. Right, first of all, we have Lawrence Aka, QC. He will predominantly be reviewing the panel today from the perspective of the tribunal, but he does not only act as arbitrator. Lawrence is a QC. He's an English barrister and arbitrator at 20 Essex in London, not only in London, also in Singapore. But I imagine that he has, for quite a stint, not been there the last half year. So hopefully that changes for you, Lawrence, in the time to come. He, as many of us today, he specializes in technically complex commercial arbitration disputes involving software, hardware, outsourcing, fintech, what is it, blockchain, e-commerce, broadcasting, regular internet, IT, and telecommunications. Frequently, he is, in addition of being counsel in matters, appointed as arbitrator, whether it's chair, co-arbitrator or sole arbitrator, and he's familiar and has been appointed under a variety of rules, including the LCA, ICC, and SIAC, and others. And maybe one last point for him is that he's one of the co-authors of the UK jurisdictional task force on legal statements on crypto assets and smart contracts. And last but not least, he's also in the IBA ICA joint task force on data protection. So I look forward to hearing his views, not only today, but also in his session during the ICA in February on this task force. But that's for another day. Lawrence, welcome to you. Second of all, we have David McIlwain here, if my pronunciation is correct. David, welcome. David will be reviewing this panel from the perspective of counsel. He is a partner at Pinsent & Masons in London, and he specializes in technology, telecom, and data disputes, with quite an abundance of experience in acting as counsel in arbitration, litigation, mediation, and all other forms of ADR, specializing in tech. One very interesting case he has recently been working on should be mentioned. He was acting for the UK government in a major dispute between the Home Office and a US tech contractor relating to the implementation of a major national security IT system to protect the UK borders. And that's a system that has been called the e-borders system. It's a very interesting case because he has conducted an 8-week arbitral hearing in which both sides were calling no less than 3 experts. So I think David has quite a bit to say on various angles, and we look forward to hearing that. One last point, David and Pinsent & Masons have authored one of the international arbitration surveys together with the Queen Mary University, relating to tech arbitration, so to say, and the publication is entitled Preempting and Resolving Technology and Media Disputes. And if David is in a position to shed some more light on particular aspects within that study, which may be interesting for us today, we're happy to hear his views on that. So David, also welcome to you. Last but not least, the panel is completed by Mr. Yves Léon. Yves is from France, as Alex already announced. He will predominantly, if not exclusively, review the panel from his dedicated perspective as being an expert and a frequently appointed expert. Yves is a well-experienced independent IT consultant. He spent most of his professional life in IT systems, working both in smaller outfits as well as in bigger companies, including huge companies such as La Poste and multinational Veolia. What he nowadays does, he develops IT operational strategies with his management consultant company, focusing predominantly on risk management, transition management, and strategic IT planning. In addition, he is frequently appointed as an IT expert, both in court and in arbitration proceedings. He's on the roster of various courts in the southern part of France as an expert to appoint, including the courts of appeal in both Aix-en-Provence as well as Marseille. He is also affiliated, of course, with the French IT Law Association, AFDIT, who is co-sponsoring this event. Yves, thank you very much also for being here today with us. Right, it has already been suggested, twice actually, that we will be reviewing the key distinctions, amongst others, the key distinctions between technical experts from a common law and a civil law aspect. So that's something that we probably want to start off with, which will include preparation of experts, but all the bar rules that are different in, for example, the US and the UK, those kind of aspects will be first tackled. And it may, in my view, be most appropriate for David to give a couple of his perspective first, being the representative for acting as counsel in arbitrations. David, it may have indeed been the case in your recent 8-week trial that you were confronted with several of these distinctions as well, that your opposing side may have been preparing witnesses in a completely different fashion than you were doing yours. David, the floor is yours.
Thanks, Dan. Good afternoon, everybody. Good afternoon from quite a rainy London. Yes, and in that 8-week hearing, I think I came across most procedural issues that could arise in relation to expert written evidence and expert examination, but perhaps we'll come on to that. But I wanted to start with what I see as the key distinctions between common law and civil law approaches to experts and generally to arbitration. Under common law, as I'm sure we all know, each party appoints an expert and they present their positions to the tribunal, adopting an adversarial approach compared to what the civil law position is, whereby a tribunal will likely appoint a single expert who investigates the dispute and reports back. And the tribunal in civil law jurisdictions tend to adopt a more inquisitorial approach, trying to discover the position for themselves rather than relying on an explanation by the parties. Also, in terms of evidence presentation, I find that in common law, the parties present the case with the witnesses and experts introducing and commenting on the various documents that are before the tribunal by way of their statements. Whereas in civil law, the tribunal will investigate the matter more directly and will place greater reliance on the contemporaneous documents without the witnesses needing to explain them. And I find certainly in the technology disputes that I progress through arbitration, that the common law approach is the more adopted approach. Now, undoubtedly that is largely driven by the fact that I'm an English qualified lawyer, but certainly that is where most of my experience lies. However, I am very conscious of the criticism that because the experts are selected and paid for by the parties, then there is a suggestion that they are party biased, perhaps less reliable, and may place a spin on the presentation of the evidence. There's also a criticism that the common law system puts greater focus on the expert's oral skills and his ability to sell or explain his position to the tribunal or a single arbitrator. So what is the best approach for technology disputes? Well, given my experience and the fact that my cases tend to involve large IT implementations that have gone wrong, my preference is for the common law approach. And in particular, I see the need for a technical case to be presented to the tribunal via written expert evidence, and for that expert evidence to be prepared by someone who has spent the time understanding the overall position. And I would say that experts generally and genuinely understand their obligations of independence and are not open to being persuaded to change their professional views, particularly where there is the very real potential for them to be criticised by the other side. Because after all, with experts, the key thing that matters is credibility. And I find that experts don't take polarised positions, but go to lengths to ensure independence of thought, primarily to protect their own reputation and credibility. Equally, I think it's helpful for tribunals in complex matters to get different opinions on the same points, so that they can balance the merits based on their assessment of the wider aspects of the case, rather than deciding on a matter through an overly technical analysis. Now, technology projects, and particularly those projects that relate to large system integration programs, can be very big, involving hundreds of people over a number of years, and a bit like construction projects. And there is a very little scope for, in my view, a tribunal to be able to read, understand and retain the detailed factual position from the contemporaneous documents alone. It will be necessary for the dispute to be presented and for an expert to create a narrative as to what went wrong. And I see that this overarching program description is important, as it is difficult to separate out discrete issues and deal with them without the wider context of the program. I mean, in my view, a technology program is a true ecosystem, and it's almost like a marriage between the main parties, involving a myriad of obligations and dependencies passing between them. And two things come from that. First, it is very rare for technology disputes to relate purely to the technology. Rather, they involve an interpretation of the business requirements, commercial positions, change, the involvement of third-party inputs, dependencies, etc. And all of these will need to be explained, and in my view, it would be virtually impossible for a tribunal to glean these without considerable assistance. Secondly, it's important to understand the positions of the parties, and for the parties to have the opportunity to explain these. A single appointed expert acting without perhaps the wider understanding of the forces affecting each party will likely seek to provide views on too strict an interpretation of the issues, i.e. possibly through the purest eyes of a technician, taking too narrow a lens, rather than understanding the nuances of what was happening at the particular time. And there's also a very real fear, particularly for counsel, that a single expert almost becomes the true arbitrator. But others may want to comment on that. That said, I do like many of the concepts of the civil law approach. I see that the focus on expert evidence should not be on oral testimony, because the content is often very complex, and conveying technically difficult positions in real time at a hearing can be very challenging. I do think, however, there's a real need for parties to be given the opportunity to bring out the flaws in the other party's case, and therefore I see it is absolutely necessary that experts have the right to provide reply evidence, so that having considered the other party's written expert report, they can put in a report in reply. Very briefly on preparation of expert witnesses. So as Stan mentioned, certainly in England and Wales, the coaching of witnesses is prohibited. That's whether it's a witness of fact or a witness of expert evidence. That's the rule both in domestic litigation, and that's our bar council guidance. So we cannot prepare witnesses in terms of the content of what they should or should not say. We can, however, give witness familiarization, which largely allows us to give general guidance about the arbitral process and what they should expect on the day, i.e. demystifying things, but we should not go further than that. And this is something I'm very conscious of. Hi.
So sorry, I just had a comment on that. If you are involved in an arbitration where you are the sole UK counsel on one side, and on the other side you have US counsel, just as in the case you were just referring to, and you touch upon the matter of this lack of ability to train the witnesses in the way that the US lawyers do. One might say that you might be prejudicing your client in a way if you then are solely on the case. And I would appreciate that, especially in bigger cases, you try to solve that situation, for example, by co-counseling together with a US qualified lawyer that may be able to work with you in different ways than your bar rules would not allow. How do you approach such a situation then?
Well, you're quite right, Stan. There are two approaches. One is, as you have outlined, and that is liaising with co-counsel who are US qualified and therefore fall subject to US bar rules. The other, and it's usually the approach that I adopt, is to seek a specific direction from the tribunal as to whether witness preparation is permitted. And we would usually put in a lot of argument as to why it should not be permitted. I have found in my experience that most tribunals are prepared to give clear direction in relation to witness preparation.
And do you feel free if you get a direction from the tribunal that you are allowed in a particular way to direct witnesses? Do you consider yourself then free to indeed do that? Because you have, on the one hand, the tension still with your bar rules that prohibit that.
That puts us in a very difficult position. Yep. The rule of the tribunal cannot overwrite or trump our bar council rules, so we'd have to look at other ways, and the co-counsel way is often the way adopted. Sorry,
I was interrupting you while you were making a couple of other points.
No, I've spoken for quite long enough. So okay, it'd be good to get others' views on the topic.
Yeah. Well, maybe before we give the floor to Yves and Lawrence, what I just heard in the introduction is that there's a bit of a distinction as to the approaches in civil law jurisdictions, common law jurisdictions. What I nowadays see in the Netherlands, which is typically a civil law jurisdiction, but I do see two approaches being adopted in the arbitrations that I am involved in, where it is not a domestic case. You see a tendency that sort of the more accepted, more common law style of expert evidence is being used and accepted, in any event, through also the application of the IBA rules that have some regulations on that. But if you are not regulating it in a first procedural order from the get-go as to how you conduct the proceedings with experts, you see a tendency that people try to adopt their, let's say, more civil law style of approach to these matters. So what you then sometimes see is that a party, instead of providing expert evidence by a party appointed expert, just offers to submit proof into the record if and when deemed necessary by a tribunal or by a judge. And there's a rule which is, I think, similar not only in the Netherlands but some other civil law jurisdictions as well, that offers of proof, whether it being factual or expert proof, can not be circumvented that quickly. But that would then lead to a second phase in an arbitration after an interim award has first been issued, resulting in a apparent need that expert evidence is to be obtained. And I'm always questioning myself why you don't try to regulate that more in the beginning stages of the proceedings, because you then have the efficiency of being able to do everything in one session, rather, and maybe that results then in an 8-week hearing. But then after that 8-week hearing, you can issue a final award rather than an interim one, and have the arbitration pending for another year and a half, perhaps. So that's one point that I wanted to make. And another one is, in the Netherlands, we have a practice, and I just heard Alex mention that's the same in France, that you can, in a preliminary basis, already obtain expert evidence, even by a court-appointed experts. And if you are not yet certain if you have sufficient evidence, that is a way how you can approach it. What I normally myself advise parties that it is more time and cost efficient if you just obtain your own expert at that stage of the proceeding. But those are a couple of quite clear distinctions with the common law system. Lawrence, what do you have to add on this point?
I think coming at it from a tribunal's perspective, my concern is to make sure that we deal with the dispute fairly, quickly and cheaply. What I want from an expert or from the party's experts or from my own expert is to help me understand the case and to do what I think is going to help me understand the case most, but also bearing in mind party autonomy. And a particular thing about expert evidence, I think, is that it is very expensive. It certainly can be very expensive. And it can add quite a lot in terms of time and procedural arguments and time at the hearing, which ultimately may not prove particularly helpful to anyone. I do find, and again, I'm an English lawyer, so I'm biased in terms of what I like, I suspect, and also in terms of what I've seen, but I do find that in a particularly technical case, parties will almost always want their own experts anyway, as you said, Stan, because the lawyers themselves, the advocates, need to understand what the case is. Sometimes you have a very technical party on one side, or maybe on both, who can provide in-house expertise, but if it's a customer buying an ERP system from a developer, the customer may actually know very little about the IT and will want to have an IT expert of their own just to help them present their own case. And often there is little point having each side having appointed their own expert to help them for the tribunal then to say, well, actually, we're going to determine this, ignoring what your experts have to say, and have a tribunal appointed expert as well, because then you end up with 3 experts and no doubt 3 completely different views rather than just the 2 you started with. And so I'm more of a fan of allowing the parties to appoint their own experts and present to the tribunal, but certainly having it all sorted out as early on as possible in the proceedings is always a good idea. Though sometimes people don't know whether they're going to want expert evidence or not. There are issues then about whether the party's own expert is tainted or, in a long-running case, can become too close to the party to provide objective evidence, and that needs handling quite carefully as well.
Yes, and in those kind of circumstances, Lawrence, don't you then sometimes see the need that it may be practical to, additionally to the party-appointed experts that have submitted their submissions already, which may have been tainted or zoomed in on particular aspects and zoomed out on particular other aspects, don't you see a need or a preference sometimes in those type of cases to have a tribunal appointed expert as well, who will be able to digest both of these lines of argument?
Yes, I mean, it depends on all sorts of things. So it depends on the expertise on the tribunal, and sometimes tribunals know enough, not only to be dangerous, but to actually be able to understand what the experts are talking about, or at least to know what sort of questions they should be asking. The other problem where there's a tribunal, well, there are 2 problems to my mind, which you have to bear in mind with a tribunal appointed expert. One is the work that requires from the tribunal, and schemes like the ICC's scheme, which Alina was talking about earlier, can help with that, with the mechanics of actually appointing the expert. The other is the perception by the parties that the case has been decided by the tribunal's expert and not by the tribunal. And in most countries, that would open up an award to challenge if there was a suggestion that the tribunal didn't really know what it was talking about and simply adopted the views of the tribunal's expert. And so the tribunal has to be quite careful to be taking advice from the expert, but still making the decisions itself.
But that's an interesting point. If they appoint an expert themselves, and yeah, they should eventually rely on the opinion of one of the experts, whether it is a party-appointed expert or it's their own selected expert. But eventually, if the matter comes down to a decision point, which is from a technical nature, how can you avoid not choosing the point of view of one of these experts, potentially the one that you have yourself appointed?
Well, I think the tribunal is allowed to take advice from its own expert, but it has to give the parties adequate opportunity to comment on that advice. So you can't take secret advice. You can't say to the parties, "Thank you very much, I've heard your submissions. Now I'm going to go away and ask my own expert and produce an award." You need to give the parties appropriate opportunities to question the tribunal appointed expert, to put their own cases, and you need to make it plain that the tribunal, it is the tribunal's job to understand what the case is about. You can't say, well, actually, I don't know anything about oil pipelines or Bitcoin, so I'm just going to appoint an expert to tell me what the answer is, because the parties haven't selected the expert. The parties have selected the arbitrators. And if an arbitrator doesn't feel competent in understanding a technical case to a certain degree, he or she shouldn't be acting in the case, I think, because they're not competent. Having said that, a lot of arbitrators who deal with technical cases, either computer cases, IT cases, or engineering cases, construction cases, are well used to dealing with different aspects of technical material, even if they don't understand the detail of the technical material, at least at the outset of the case. So now I know a lot about a lot of very small and unconnected different areas, none of which is particularly useful to me, whereas an expert, of course, will know a lot about everything.
So, Lawrence, have you also been involved in a similar situation as David has, where you're facing either yourself as counsel or as arbitrator, but a UK counsel on the one hand, or and US counsel on the other hand, where you see a distinct different approach in prepping the experts? And if you have seen that in a case where you were arbitrator, how did you ensure a equal treatment of the parties?
Yeah, well, again, it comes down to being alert to the possibility at an early stage. I've seen it not in the expert situation, but on the disclosure side, where, again, an English lawyer is used to requiring the client to produce all documents, whether good or bad, in a case. A French lawyer might consider that to be professional misconduct to disclose documents which are unfavourable to his or her client's case. And that's not because one side is necessarily right, it's just because of different legal traditions. And so as arbitrator, you have to be alert that this is going on, and not just assume that because you are an arbitrator versed in the English or US common law tradition, that everybody approaches it the same. And I've done a case with Italian counsel on one side and English counsel on the other side, and we had to make sure we brought out all these aspects into the open in advance to say, what are you going to be doing? And this is what disclosure you have to produce. This is how we expect the expert evidence to be presented. It's also relatively obvious to a tribunal, perhaps more obvious than counsel would like to think, when a witness has been coached. And that goes to the credibility of the witness and to the weight that the tribunal puts on the evidence. If they think the witness doesn't genuinely believe that what he is saying is really true, or has some qualifications which his lawyers told him not to advance, then an alert tribunal at least should be able to dig into that a little bit more.
Well, thank you for that, Lawrence. Yves, I imagine that you have been appointed in both common law and civil law style proceedings yourself. How do you see those differences play out from your perspective as being the expert who might or might not be prepped, and issues like that?
Well, thank you, Stan. as you know, I am still involved in the American environment. I've been involved in the American long ago when I was consultant for the CEO of Pacific Bell, and that was the beginning of the internet. So I really do appreciate the enormous difference we have in the legal environments. And I'm still involved now being at Columbia University of the City of New York. Really, it's difficult for us to, perhaps difficult for the audience to imagine the difference we have in the legal environments of the Roman, I would say, not only French frame and the frame you have in England, in Great Britain, or in the United States. To give you some examples, we are not so much concerned by the difference you made between civil and common law. We are more concerned with the fact that we can be appointed by a judge, I would say in a normal tribunal, or we can be appointed by an internal chamber of arbitration or a counsel like yours. And that is a completely different environment. When we are appointed by a judge, first, we are acting as an actor for the Department of Justice, and that creates rights and duties. And these duties are very severe. I'm sure that Alexander will help me perhaps in being more precise in the details, being a lawyer in both bars, but this is an enormous difference. It means, for example, that when in France we are asked to help a lawyer to be a lawyer expert and not a judge expert, we must follow the rules of the expert for the judge. We can't create facts, we can't cheat, we can't lie. The only thing we can do, and that the real limit, is not to mention something we know. But even that is so and so. So it's not exactly the same approach than the one you are presenting, of course, but I happen to be acting as an expert in a big arbitration. The issue was $300 million, so it was quite big already. And it was difficult to make the American party to understand that I had to be very, very strict and very clear on my independence on the position I was taking. I can't be prepared, for example. You asked the question, can you prepare? I can't, I am not allowed to be prepared. I have to be very strict. And to me, this point is very useful because it clearly means that this independence gives a real balance of what the justice must be, as close of the reality of the truth as possible. Since even though I just said that, at the same time, I am very impressed by the fact that all the cases we have to deal with are now very, very complicated. The technical layers, I am expert in IT, as perhaps you understood. In IT, I've been there for a long time now. I'm still in action. These days, today, tomorrow, I'm in managing a big crisis between an editor, an integrator, and a big international company. The RP is not working, to make it short, or not working the way people thought it would be working. It's more and more difficult to find the truth. That's one of the points I'd like to defend.
Yves, I just wanted to pick up on one comment that you make, that you say that you can't be prepped as an expert. Does that also then rule you out as a potential expert for any and all US counsel? Because they are... Sorry?
No, then I follow your rules. I follow the US rules, which is different.
Oh, okay. So you are flexible in that.
I was just saying, the feeling of common law, civil law is not the feeling we have in France, or even in Italy, in Spain. Deutschland is a bit different. Germany is a bit different, I mean, sorry. But when I'm working under the American law, it's different. I follow the American law, of course. But to the points I was on, which is a bit different, it's really very, very impressive to understand the number of technical layers you have to deal with, and so the number of actors you have to deal with, which creates a big complexity in finding the responsibilities. It's more and more never this yes or no. It's more and more sort of gray and really difficult to find the truth. Which means that arbitration. That's the point I wanted to finish this short introduction. Perhaps arbitration is very good for that reason, because the law is not able to be very proactive with this complexity. It's too complicated for the law, which is paragraph and paragraph and paragraph. The law is not able to approach the complexity of a big phenomenon. It's very long first for the legal approach, and also it's too complicated. Arbitration is, I would say, more intelligent, with no bad thinking on the word intelligent. That's why I do everybody, every time it's possible, go on arbitration and don't go to the court.
Well, everybody here in this forum is obviously very happy to hear you say that, Yves, I'm sure. Hey, now that we're a bit on the topic of your changing hats from various perspectives, being in the US or being in France, you have also been appointed as party appointed expert in many proceedings, and on the other hand by courts, by the Court of Appeal in South France.
Not only South, even the French Supreme Court.
Oh, sorry, it's way more broad. But court appointed on the one hand, party appointed on the other hand. Do you in those different roles see that yourself have basically a different mandate in a way, or do you consider your task to be principally the same?
Well, it's a real question. It's very difficult. We are supposed to be independent even when we are working as a lawyer's expert, which means party expert. But in fact, to make it short, we are closer of the party which is appointing us than from the other party. So it's not exactly the same. The same psychological environment we are in. And also, we are not able, when we are a party expert, to go and speak to the judge. When we are a judge expert, the office of the judge is open to us. And these days, I see a judge twice a month on a very difficult case we have, to ask him, is it what you want me to do? What do you think of this situation? I am the armed arm of the judge, so we have a close relation, full of confidence, mutual confidence. Of course, when I'm a party expert, no way, it's not possible to go and see any judge. So it makes a real difference.
Yeah, well, then we come back perhaps a little bit on the point that both Lawrence and David also briefly touched upon, and it's the perception that one might not be completely neutral in a setting if you're party appointed. I've heard the term hired gun as well, and it comes down to the credibility sometimes of the experts, and that's a difficult point, I think, to tackle from all perspectives. And on that point, Alina, our speaker of just now, also had a question to ask. Alina, would you be so kind to proceed?
Thank you, Stan. It's more of a comment, and I wanted to share that, I've seen a few times parties coming and requesting the ICC, International Center for ADR, to propose an expert in order precisely to avoid this image of a hired gun expert. And I've been told after the hearing that throughout the whole hearing, the counsel and the party having appointed that expert was referring to him as the ICC appointed expert, just to avoid this impression of a hired gun. And I was wondering how would Lawrence react to that? If you would be reassured that, you know, the expert has been appointed by the ICC, so to use Eve's words, is less closer to the party which appointed him because it was appointed by an institution.
Yeah, well, if the parties are happy to have a tribunal appointed expert, then I would have no problem with that at all. And it's interesting to hear you say, Alina, that parties do come to you to say, we positively want a third party expert to assist the tribunal to avoid that perception. Certainly in the UK, all experts here in English court proceedings, as David will know, have to sign quite a long declaration of independence. And most of the so-called professional experts who are used to dealing with court proceedings and arbitrations are pretty good about telling their lawyers, no, I can't do that, or I've got to say this whether you want me to or not. And they have to put that declaration in their written evidence. So it's, but still occasionally you get experts who are obviously partial to their appointing parties, same as unfortunately you get arbitrators who are partial to their appointing party. And it's just something the tribunal has to deal with. I'm not sure, personally, I would be insisting that there be a tribunal appointed expert just to avoid the perception of bias, because I think it creates other problems that are outlined that the expert then might be seen to be determining the case. Interestingly also, in the UK, we have a procedure in court hearings for the court to appoint an expert. Certainly I have never, I think, David will have something to add to this, but I don't think I've ever had a case in which the parties have said, yes, we want a court-appointed expert. And I've only heard of it being used in fairly small value cases where it's simply not worth the parties appointing their own expert. So it's not really taken off here, but that might be because of our legal tradition.
Lawrence,
coming.
if you want, because I was not clear enough. When I am appointed by a judge, I have to declare that I have no conflict of interest, knowing one of the party or whatever. And to give you an example, on a social network, I put some mention on the value of a new software of some company, which everybody knows, of course. The judge told me, well, you shouldn't do that, because if there is a case in which this software editor would be acting, you couldn't be appointed as a judge expert just because you said that the software is good or not. So it's to say how strict it can be. When I'm working for a lawyer who is acting for one party, the case judge, I have to respect this, to respect the same rule. But if I give the conflict of interest I could have, and if the lawyer decides that it's not a problem, I can go on. When I'm appointed as an expert in some arbitration, that is very different. I have to be acting exactly as the way I'm acting for a judge. If I have a conflict of interest, I'm not neutral. And of course, the ICC would have to know it before appointing me or proposing my name. That's very clear. I don't know if this helps, Alina, but it's just to make it a bit more precise than what I did before.
Just coming in on a couple of points there. First of all, on Eve's point, I certainly find that most experts, most technical experts in the UK will not comment or publish materials because they don't want to be prejudiced. They don't want anything coming back on them which might indicate they had a bias or some pre-existing view on something. So most experts are very clean and simply do not publish materials. Secondly, what Lawrence said about experts in the UK in litigation, in domestic litigation, and the the lengths that the court goes to explain the obligations of independence. And that really does then trickle down to the counsel who are advising. And certainly from my perspective, the last thing I want is an expert who simply repeatedly opts for the position that is the most favourable to me and my client, or, for example, will defend points beyond a reasonable degree, because that just smacks of credibility issues, and that will become very, very clear to the tribunal. So we do take our obligations of independence of the experts incredibly seriously, and it's exactly what we want to impress on them, so that they can produce balanced reports which are much more likely to be accepted by a tribunal.
But Dave, just to give examples, let's speak once again of the cloud technology, which is on the really the one everybody is working on. Being an expert on cloud, you have to compare the different technology, and you can say this one is so and so. Even if you are not in a process of criticism, you can make public the fact you know this technology, and knowing it, you can be positive or negative. It's difficult not to say anything and to be known as an expert in cloud, to make this example. Now, I'm working for Nutanix, which is one of the big rising stars in this field. Of course, if I had any case coming on cloud, I would have to declare, well, I've been working for Nutanix this way, and if this is prohibited, I have to stop. That was my point. Difficult to be good. I'll take an example. I'm a member of the board of the National Council for Expertise in all fields. The judges don't want to have professors in surgeons who are involved with labs. But the best professors in France, at least, but I think it's the same in the world, all of them are involved with labs, because they have the knowledge to help the labs to develop such proceeding. So it's very difficult to find a high-level professor of medicine not involved with a lab or a prosthesis builder, and at the end you don't find good experts. So it's a very narrow way we have to follow, all of us, I think. And at the end, Stan is right. It's a problem of independence, of estimation of the quality of the people, of reputation, of course.
Yeah. Well, thank you for that, Yves. I had an additional question to Lawrence to begin with in any event. If you are confronted with a situation where expert reports are being submitted to you as an arbitrator by the parties, by a party-appointed expert, you might see the situation that either both or one of the experts does not zoom in on a particular issue which you might consider to be of interest. And you've just expressed your opinion that you're not always in favor of appointing a own independent tribunal appointed expert. But how would you then go about to ensure that all important elements that you consider necessary to reach your decision are being reviewed by both of the parties? Will you go about and issue specific written instructions for the parties to highlight certain issues that they have not covered or have not covered in sufficient detail yet? Or are you going to direct questions during examination in a more specific way? How do you go about that, Lawrence?
Well, like most lawyers' answers, it depends. One thing you can do in advance of that happening is to make sure that there's clarity on the issues that the experts are going to address. So you can invite the parties to agree a list of questions for the experts or a list of topics, and it can be anything from 3 broad topics to 20 specific questions. If one of the experts has simply not dealt with something, you can arrange for the experts to meet, to discuss things, to see if they can agree things. You can raise it during an evidentiary hearing, but you obviously don't want to be taking someone by surprise. But equally, you can't afford to have an issue which you think, in your wisdom, decides the case, but which the experts haven't covered, one or either of the experts haven't covered. You can't decide the case on that basis because it's not fair to the parties. So you have to make sure that you've raised it either in writing or orally at a hearing. And certainly you can find that when you raise your question, it turns out miraculously that you as the tribunal haven't actually understood what the issue is after all, and the experts do in fact know far more than you do about the case, which is what tends to happen. But yes, you have to raise it. I'm quite a fan of having expert issues delineated in advance if possible, but it's not always possible because some people don't know what the issues are till it's fairly late on in the case.
No, that's a follow-on question, of course, because you would then preferably tackle these kind of issues at the very beginning in the arbitration, potentially even already when you're discussing the procedural timetable to set that out when briefs are going to be submitted, and will there be a sit-in with the experts if you're planning a hearing, or won't there be such a session? But if that only develops after the submission of the first rounds of brief where the first expert reports have been submitted, and it's oftentimes only after that point in time that you see that there is disconnect that needs to be clarified and whatever. Whereas in other cases, you might not end up there because there's an alignment on certain key issues. But tackling it quickly, I understand your inclination, but that's really tailor-made, of course.
Yeah, and also if you have 2 rounds of expert evidence, so you can either obviously exchange expert evidence, so each side serves its evidence at the same time, or you can have consecutive rounds. But usually you will find that if there's an area which one side's expert simply hasn't covered, they will realise that when they see the other side's expert evidence, and they will deal with it in response. And you just need to make sure that everybody's had an adequate opportunity to comment on everybody else's evidence.
Yes, and if they don't do that, that's their decision, of course.
Yeah, if they don't do it, then fine. But they've had the opportunity. Yeah.
All right, David, any additional views on this?
Very similar to Lawrence. I'm a big fan of lists of issues. So having the parties and the experts agree what are the issues which need to be addressed, which will then inform the arbitral panel to make a decision. And I see that as an incremental process. So it's common to have lists of issues agreed before expert reports are exchanged, so that the expert reports are meeting the issues that need to be dealt with. But these then can be refined, and as Lawrence said, in terms of your second round of expert reports, your reply expert reports, you may want to refine some of the questions if there's a view that what's been written to date does not quite hit the point. I have never had a tribunal raise an issue which was not on the list of issues. Cynically, I may say because the tribunal had not grappled with the issues until they were actually in substantive hearing. But if that were to be the case, I would have thought the most sensible thing to do would be for the tribunal to make a suggestion that the experts go off and think about a particular issue, and report back on that issue. But I've not come across it.
Okay, thanks. What was briefly touched upon by Lawrence is experts meeting and agreeing potentially on certain matters. There's the question, at what moment in time one could be best set out to do that. You can try to achieve an agreement on a couple of issues before a hearing, during a hearing. You can do it through the tubbing of experts. What kind of approaches do you see, David, and what do you prefer?
So again, this is quite common in domestic litigation in the UK, and I've used it extensively in international arbitration matters, and that is to require meetings of the experts during the process. in order to try and narrow the issues that are between them. Because you would like to hope that the experts are able to agree certain matters, so that those matters, there is an underlying understood position, and that will then allow them to focus on, well, where are the issues that we cannot agree, because those are then the ones that will need to go to the tribunal to consider, and we will need to focus on and address in detail in our expert reports. So I would look to have a direction that experts meet before they exchange their first expert reports, to see where are the areas of commonality and to identify where they cannot reach agreement. And then the focus of the written report should be on the areas where they cannot reach agreement. I think it's also then sensible to have those meetings after expert reports, because they may change their position having seen the expert report from the other side, or it may allow a more informed discussion on their particular point. So I see that it is a continuum, a thing to be discussed, so that as you near the hearing, it should be clearer what are the actual technical issues that you require expert opinion on, and where are the areas of disagreement.
Yeah. So what I take away from your comments now is that you prefer to get such an agreement already really early on in the proceedings. What I normally see in these type of cases is that you leave it more up to the parties to decide what they consider to be necessary to be put into an expert evidence report, and only have the ability to go ahead and try to come to any form of agreement not earlier before the first round of written submissions together with expert reports is completed. But you're basically a supporter of even getting
earlier.
Those decisions in at an even earlier time. Do you see a willingness on other parties to go along with that? Because that's not, well, in any event, not from my perspective, the typical way to approach these matters.
So we have a I would say we have a reasonable chance to agree something like this, but I would say that we tend to make more progress after expert reports have been exchanged, because experts are reticent to agree points before they understand the full implications of conceding perhaps some issues. But certainly, we think the conversation should start at an earlier point, and it very much is a funnel. So you usually start with, getting the real basics and an understanding of the real basics, and then it's only when you begin to progress through the report and the reply report positions that you can actually get to a point where you can make agreements which have real substantive value in the dispute resolution. Yeah.
Well, thank you for that. Moving on now, perhaps to the perspective from the tribunal as to the moment that an agreement can be reached by the party-appointed experts. But Lawrence, what's your preference in terms of timing? And do you instruct parties, for example, to already at such an early stage as David alluded to, come to such an agreement on certain key issues?
I would almost always suggest it, and it almost always doesn't work, because usually for reasons of expense, that the parties won't have, or maybe one party won't have wanted to spend so much money on their expert before they get to the stage of experts' reports, really. So it's back-end loaded. The money comes in just before the reports go in, and people are worried about sending their expert into a room with the other side's expert, presumably in case they give too much away or something. I mean, it's incredibly helpful for a tribunal to have a good list of agreed issues. Unfortunately, it often ends up that the list of agreed issues is 3 items which don't matter very much, and then a long list of, well, we might be able to agree this, but Mr. So-and-so hasn't thought about it very much yet, Miss Y wants to read some more documents before coming to a view on it, which is just not very helpful to the tribunal at all. And the other problem you get is one that parties sometimes are worried that if their expert goes into a meeting, they are going to give too much away. And from a tribunal's perspective, that's not really my concern. And in a sense, I would rather them give away all their bad points, because that saves everyone time and money. But I don't think I would impose experts' meetings against the will of the parties, unless I thought there was a very good reason to do it. But I'm a great fan of having a meeting, at least at some stage. It does tend to be after first round reports have come in and people can see what the other side's views are on various issues.
Yeah. Yves, what's your point of view on that?
I was smiling because it happens very often due to the complexity that one party delivers a huge amount of documents, perhaps with the idea of put you in a bad position, saying if you have, I don't know, 10,000 pages to read, you won't read them. But if the high level can tell you that we read the 10,000 pages, and sometimes we find in the documentation given by a party arguments against this party. And this is more often than what you think. That's why I was smiling when Lawrence was speaking. Experts can be, in French we would say, scoring against their camp without the feeling they are doing it, of course, not on purpose. But that happens more often than what you think. So you have to control your experts for sure.
Yeah. So one additional point that we briefly discussed earlier on was I think it was the suggestion made by David to have a sit-in on technical matters with the tribunal a day or several days before the actual hearing starts. David, I was not really familiar with those kind of practices, and I'm not sure if others are. Would you care to shed some light on that practice for us?
Sure, Stan. So this is something I've used in a couple of arbitrations, where effectively you invite the tribunal to a teach-in half day, maybe 2 or 3 hours, and you invite the experts to give an initial introduction and overview to the technology at issue, asking them to explain and describe some of the key terms and the areas that are going to be under scrutiny by the tribunal. And I'm not suggesting that the experts lead with any evidence or discuss matters in detail. It's simply they are describing what is the technology about, and what does it do, almost speaking in business terms rather than technology terms, and explaining then where are the areas where the parties are at differences. And I think it's a good opportunity to use visuals and diagrams to bring the technology alive, rather than using a lot of technical jargon. And I do think this is of benefit to hold before the hearing, and particularly before perhaps the tribunal have really gotten into the detail of the expert evidence, because it's an introduction. It's a safe area for the experts to explain things to the tribunal, and for them to ask any elementary or basic questions, so that whenever they begin to tackle the expert reports, they do so with some knowledge and understanding. It also is good from forcing the experts to collaborate, and that may indeed even lead to a further narrowing of the issues. And it allows the experts to acclimatise and to become a bit more used to this particular tribunal. It's also interesting from a counsel perspective, because we pick up on what the tribunal is finding of interest.
Yeah. David, Yves, any comments on that approach? Have you been using that yourselves, for example?
It's not something I've not had a teaching session. I've certainly had technical briefs prepared for the tribunal in writing, ideally by both experts. So there will be a long document, maybe a few dozen or even longer pages, setting out for someone who doesn't know anything about this area of technology what it all means. And it's much more useful to get that in advance. Sometimes you get that as an appendix to an expert's report, which is fine, but it's sometimes better to have it in advance. I do quite like the idea, I might steal it, of having some kind of teaching session in advance. I mean, and I can see it's good for the experts as well, especially if they're not used to giving evidence. They can just come and make a presentation in a fairly relaxed environment. Because
what I normally try to do myself is incorporate, let's say, a technical explanation chapter in a brief, but that's just the point of departure. And I had an epiphany when David mentioned this first. You can write such an introduction for the tribunal in a brief, of course, and it needs to be there as well, but it has an added value to be able to have an open discussion with tribunal members on those basic technical issues. So you might steal it, I might steal it, we might all go and steal it. But credentials go to David.
Stan, can I, this is Les, could I offer a thought?
Sure.
Yeah, actually the technique that David has outlined, I have used for years when I was a counsel and presently use as an arbitrator. But I have a bit of a different twist, and then I'd like David's view on that. As opposed to using the experts to explain the technology, my focus has been to have technology personnel from the individual companies schooled not to be advocates, but to explain the technology from their position, the individuals who worked on the program, either typically at the beginning of the hearing, and sometimes even before the hearing, the official hearing commences. So what do you think of that, David?
I think that's really interesting. I've not come across that before. I think my immediate thoughts were if you're having technical people from the supplier and from the customer, often we find that disputes relate to a misalignment between the customer's business expectations of what the system or IT is going to do and the supplier's technical understanding of what inputs need to go in order to make the technology work. Those sort of issues may then come out if you're having those discussions. But I like the idea, and that may well translate into a more sort of business understanding by the tribunal as to what the system is all about, what it was supposed to do, and because everybody implements IT systems to meet a business or organizational solution or need, I think it's very useful to put that in context.
Thank you.
Stan, perhaps a few things. First, in the situation of doing that in arbitration, but I think that would be great. That would save a lot of time and a lot of perhaps lack of comprehension. Second, when you are working for a judge, you can do it, and it happens to me not very often that the judge asks me, explain, tell me what, because he's judging many different things. I'm not specialized in the technical aspects. He has to deal in that precise case. So this is private, but it's not illegal at all. And you explain, and that helps the judge to ask perhaps more precise questions during the session. 3, when you are appointed by the judge, you're allowed in France, it's not arbitration, of course, but you are in France to ask somebody who is better than you in a precise field to come and help. The rule is that you can't ask somebody to help in the field you are supposed to be good in. Otherwise, it means that you are not a good expert, of course. But let's assume that you have to fix some penalties, financial penalties. You're expert in IT and not in finance. You're allowed to ask somebody to help you there. This person is working under your responsibility. So you will respond of what he's saying, which is not exactly the question you are asking, but it's could be doing the same way. And last point, I think it would be of great interest for us that in some cases, taking perhaps 1 day, 2 days, we would have real-time operations in front of the tribunal, in front of the judges, instead of putting them with enormous reports, written reports, full of screens, which are not very easy to understand, showing it works, it doesn't work, and of course, allowing the parties, both parties to react and explain their point of view. That would be a big progress. And I heard that the La Cour européenne des droits de l'homme, the European Human Rights Court in Europe, is working on this idea for the next years. So it's an open world, which to me is very important. It's a bit surprising that we are all working on real time. Let's see what we're doing now. We are all around the world speaking together. We can't do that with the court up to now. Why?
Well, thanks for those additional comments, Yves. I think if we look at the time, we have a couple of minutes to fill still, but I would like to raise only one last general topic that we can discuss before closing our panel session, and that relates to the distinction of court and arbitration proceedings and the time efficiency aspect. And I know, Yves, you had a couple of views on that to share. So I'll first give you the floor, and then I have a couple of additional comments and questions for David in any event as well, because I'm very curious to learn if he would have considered that 8-week hearing in arbitration to potentially have been conducted more time efficiently before the High Court, for example. But first, Yves, please shed your light on.
Well, no, it's going to be very, very short. I have bad experience on arbitration because some parties were not playing the rule, I would say, not respecting the rule. And it happened that some arbitration as long as a normal tribunal would have taken. So that was not a big result. That's my point. But at the same time, of course, in Europe and in France especially, the time is something which is playing against the business. Bless you. And any case is very long. It's never less than the control of lawyers. And for example, Alexander, it can't be less than 1 year, more or less 2 years. Sometimes if there is an appeal and something, it can be 5 years. So arbitration should be much shorter, but be careful not to be delayed for some reason. That's I would say my point.
Yeah. Thank you. David, your comment on my question in relation to your 8-week trial in arbitration. Was that necessary? David?
First of all, I have to unmute.
Yes.
So was it necessary? Well, if this matter had come before a court in London, I have no doubt that it would have taken longer than 8 weeks. Right. It was incredibly complex. It was a very big dispute. It had a value of over £1 billion, and it had a large number of IT technical issues. It had significant program management and delay analysis issues, and it had a large number of quantum and forensic expert issues. So I think it would have been a a disservice and potentially a misjustice if we had tried to tackle what was extremely complex in a shorter period than 8 weeks. However, I do see that there could have been some efficiencies. I think we could have perhaps reduced the amount of expert evidence in terms of oral presentation considerably if we had time boxed the amount of time that was available for expert evidence, because there was a significant amount of written expert evidence. So a lot of the matters could well have been dealt with by way of paper. But I go back to in London, in the UK, we have what's called the Technology and Construction Court. So it is a court which is tasked dealing with only construction and technology matters, and I'm quite certain that this would have been listed for 12 to 16 weeks if it had been in that court. So in this particular instance, arbitration actually led to a shorter hearing. So I think that is a significant benefit.
Yes, thank you. And Lawrence, how do you try to ensure time efficiency if you're on the opposite side of the table and you might only be confronted with expert evidence later in the proceedings rather than sooner, which might cause a delay if you want to ensure that all parties are properly being heard?
It's very difficult because parties do tend to insist on spending lots of money and taking a long time over things. At least that can often be the perception. And it's a case of saving them from themselves quite often. Some arbitrators take a very laid-back approach and just let things carry on until they find themselves at an eventual hearing. Some, and I hope I'm a bit more like this, try to be a little more interactive and get a grip at an earlier stage. And sometimes it is persuading parties that they really don't need 16 rounds of submissions, and actually you have figured out what the point is after the first 3, maybe. There is a tendency for parties just to keep going till someone blows a whistle and tells them to stop, and it's blowing the whistle at an early stage, I think, which is important, whilst making sure everybody feels they've had an adequate opportunity to make the case.
Yeah.
And that is an interesting, for me it's interesting acting as counsel and as an arbitrator, that you do see the difference in approach from both sides. As counsel, you obviously want to put forward your client's case, and maybe you are tempted to say the same thing 15 different ways, just to make sure the arbitrator's got the point. From the arbitrator's perspective, that's really not terribly helpful at all. And you do see, maybe 60, 70, even higher percentage of points made by counsel are pretty much not terribly helpful to the tribunal.
Yeah.
So same for experts.
I've been appointed recently as chairman in an arbitration where the parties had a very laid-back approach as to the conduct and timeline of the proceedings. And then the first thing that springs to mind from my side is, well, I'm here to service the parties, and it's the party of the parties in a way. So during a case management conference that we conducted with the parties, the outcome was, well, both of the sides are going to submit a first written submission, and after that written submission is submitted, we're going to organize a new case management conference to see what the rest of the procedure is going to look like. Claimant was not yet in a position to even inform the tribunal as to when they expected their expert that was working on a particular expertise report to be done with its task. So they started the arbitration and they wanted, for some reason, a very flexible attitude, but the opposing side felt the same. They didn't have a real urgent need to proceed. They considered it pretty fine to just take a similar approach. And in those kind of cases, if there's an agreement of the parties to, well, not be time efficient, well, who are we then as arbitrators to decide that the case should proceed very quickly, right?
Yeah, it takes everyone to cooperate, and if they cooperate, it can work very well.
Yeah, yeah.
If they don't, someone may need to get a grip at an early stage.
Well, we might at one moment in time try to bring across the point that with this attitude, if that's going to last, the proceedings will continue endless. But again, if that's what the parties want, I'm generally fine with that. But right, thank you, Lawrence, for those comments on time efficiency. Talking about time efficiency, it's bang on the clock, 7 o'clock. So we have completed our panel session right in time. Thank you very much, Lawrence, David, and Yves. Some questions have been posted in the Q&A session, and I'm sure that after Krengruta has provided her points during the Q&A session, there might be a couple of questions to you guys. Thank you very much, and it's over to Alex again. Alex.
Yes, thank you, Stan. Wonderful session. Our next speaker on this panel is Krengruta Leao, who you see on the screen. And Krengruta is with the LDDP firm. She is specialized in international commercial law and arbitration. She has worked as an arbitrator in many cases, most under the rules of the ICC and of the Court of International Commercial Arbitration attached to the Chamber of Commerce and Industry of Romania. She was a member of the ICC Court from 2012 to 2018, including 3 years as vice president of the court. Krengruta also has an attachment, an affiliation with the SVAMC, as she is on the tech list. So Krengruta, please, you have the floor.
Thank you, Alex. And I'm very, very glad to be here in the position of presenting you this initiative, recent initiative of the CFAMC. And I'm happy that together with me today are also my colleagues in the working group. The working group of this initiative included Manuel Gomez. I can see that he is a participant in this call as well. Carl Hennessy, Uchaora Onwa Megbu, which is also here. Uche, I can see you. And Lester Schiffelbein, and also Sarah Thomas. All of us, we prepared a document which is open for further discussion, and we are very much welcoming any comments and views in the future. That is actually the purpose, to launch such discussion. And then please allow me to present you the initiative. This is a new initiative aimed at creating awareness of and dialogue about the technology tools that could permit the efficient use of international arbitration and mediation in the resolution of disputes related to blockchain-based transactions. So the key word here is blockchain-based transactions. With classic business model increasing nowadays and migrating towards digital trading platforms that rely on new technologies, focus is shifting to the available means for resolving disputes that arise from these blockchain-based transactions and from the use of tokenization and smart contracts. These are at the core of the new realities of the technology-based commercial transactions. And this sometimes, of course, incorporate automated methods for resolving disputes, including self-executing outcomes. International arbitration and mediation must adapt to the evolving needs of the business world, and the emerging technologies must adapt to the realities of the tried and tested systems for resolving international commercial disputes. Achieving this would require the inclusion of interoperability interfaces in the technology used for solving these disputes. The immediate goal of this initiative is to raise awareness and generate dialogue within the relevant businesses and the dispute resolution communities around the world. This is in order to respond to the need to ensure interoperability between the international arbitration mediation on one hand and the new technologies based on transactions on the other hand. And what we thought is of a list of steps to accomplish these initiatives and the goal of this initiative, and that would include, first, adopting best practices for arbitration and mediation and creating bidirectional gateways in the new technology platforms that would enable automated initiation of the proceedings, collection and integration of data to be used as evidence, production of arbitral awards and or mediated settlement agreements in a format that is compatible with the relevant digital platforms, and automated enforcement of the arbitral awards and or mediated settlement agreements. That would be a first step. Another step, equally relevant, would be adapting the relevant domestic and international legal frameworks to integrate and accommodate the peculiarities of technology-based dispute resolution mechanisms and to ensure enforceability. A third step would be the training and the information that needs to be provided to the international business and legal communities, including the users and the providers of arbitration and mediation services. And this is in relation with the new technology-based mechanism of dispute resolution. A fourth step is a dialogue that aims to identify and develop further measures in consultation with states and international organizations, businesses using or migrating towards the new technologies and using blockchain technology and smart contracts, companies in the blockchain industries which are providing the technical support for such changes, the arbitral institutions worldwide, the arbitration practitioners, arbitrators, mediators, counsel, experts, and academic and scholars. All these are part of the dialogue that we aim to achieve. And this initiative welcomes, as I mentioned, questions, comments, and proposals, all of them to be sent to us, the members of the working group, on a collective email address that is bill@cfamc.org. We would welcome such questions, comments, proposals by September 15, 2020, namely this year, because we would like to move forward with the steps to be taken following such collection of comments in this autumn. So I hope that this is a teaser that would make you want more information and actually want to share more information from your side. And I'm very happy to have, as I mentioned, with me today, also my colleagues, Manuel Gomez, Uche, and Les. If you would like to say some words about this work that we are starting together right now, I would be very happy if you could take the floor. And thank you very much.
Well, this is Les Kinguta. If I may start out, on behalf of the committee and Silicon Valley Arbitration and Mediation Center, we wish to thank you for your initiative and enthusiasm, and actually being the individual that brought this initiative to us, and your hard work in herding the cats on the committee to get us to where we are now. It has been fantastic, and kudos to you.
Thank you.
I'd also like to mention that the initiative was posted this morning, a white paper on it, which contains a little bit more information than Kinguta's comments, was posted this morning on the Silicon Valley Arbitration and Mediation Center website under the rolling banner headlines on the initial page of the website. One of the things that the leadership of Silicon Valley is most excited about in this initiative is that the charter of our organization, which is about 5 years old now, is to promote alternative dispute resolution in the tech space. And our vision contains a statement that we will do this through enhancement and being thought leaders on technology tools. And this is really our first substantive movement in using technology tools, providing information, bringing the parties together that can best affect implementation of these technology tools, which will lead to more efficient and effective international arbitrations and mediations. So the enterprise is excited about it. As Kengruta mentioned, if you do have comments, please contact Kengruta or other members of the working group. And we do have also a website address in the white page initiative, which we posted today. But again, thank you, Kengruta, and thank the other members of the working group, and also the support and encouragement of the leadership of Silicon Valley Arbitration and Mediation Center to get to this point. Well done.
Thank you very much, Les. Uche just posted a message on the chat. Thank you, Uche. Manny, I'm not sure if you can connect audio or by a message, but if you can't, your hard work on the project is duly recognized, and thank you so much for all the help. And we are looking forward, all of us, to still work on the further inputs.
Wonderful. Thank you, Krenguta. And thank you for the introduction to that project. Very interesting. The fourth part of our panel is now, and this is the Q&A. And it was Q&A about any aspect of the panel from the beginning to the end, to Krenguta's presentation. And we have one question. Folks out there should think about additional questions. I will start by reading the question that we have from Paul Mason for David. And so the question is a California style question. What is your experience, if any, with hot tubbing? I take it that's not the California hot tubbing, but the arbitration hot tubbing, i.e. pre-hearing communication between the respective party experts to refine the issues they are dealing with, etc.
Okay, so I think I've talked about that in terms of I'm in favor of experts meeting before the hearing to try and narrow the issues and refine the areas of disagreement. But I also have experience of hot tubbing in terms of the experts taking the witness stand at the same time, and then answering tribunal questions on an individual issue by issue basis. And similarly, I've had good experiences of that. It allows the tribunal to ask, to spotlight on specific issues and then hear immediately the view of one expert juxtaposed with the view of another expert, so that they can get effectively side by side the experts' views on particular matters. And with technology, because it can be very complex and it can be difficult to retain all of the technical information, hearing issues like that on an issue by issue basis can be really useful. I would exercise a couple of cautions. First of all, I am not in favor of experts asking each other questions in the hot tub. It really should be for the tribunal to put the questions. And equally, I would always want to ensure that the party appointed expert is addressing its responses to the tribunal. I would want to avoid getting into a discussion between the experts, because again, I think that can lead to some unexpected consequences. And thirdly, I think there needs to be quite clear guidance from the tribunal as to whether then counsel has the opportunity to cross-examine and re-examine the experts whilst they are in the hot tub, because if you don't have that clear understanding, that can lead to procedural questions.
Thank you, David. So I have one comment and one question while we're waiting for more questions from the audience. The question was about the very interesting line of questioning or discussion that Lawrence and David and Eve had about preparing witnesses in international arbitration, and in particular, whether there is a competitive advantage by jurisdiction for those jurisdictions like the US jurisdictions where the attorneys can really prepare in the American sense of the word, whereas in civil law jurisdictions, they might be prohibited by bar rules from doing that. And I wanted to note that there was quite some debate about 10 or 15 years ago about this very issue, especially in France, where Paris was trying to become and stay a competitive leader, and saw the civil law rules that prohibited preparing witnesses as a severe competitive disadvantage, because the French lawyers would not be able to prepare prior to hearings to the same extent as the American lawyers, who would be coming into Paris before the hearings and preparing their witnesses. And as a result, the Paris Bar Council, after consultations with the bar, with the Ministry of Justice and the ICC, adopted in 2008 a resolution that creates a carve-out for witness preparation specifically for international arbitration matters. And you can find it on the Paris Bar Council website. But it could be a serious competitive issue, as Stan pointed out in his comments. And so my question for Eve is, we saw the common law, civil law tradition comparison and some of the differences. On this panel, you have practiced in both as an expert. You've been appointed by parties, you've been appointed by judges. Which do you prefer? Which gets the best result? Which is most efficient, and why? In your opinion, of course.
Well, I was not prepared to that question. That's an open question. Well, it's very difficult to answer, to be serious. I think the rule we have in force is perhaps gives a better balance and a better chance to all parties. To me, it's more clear. So I would say that the rule I prefer. It's very difficult to be sure that nobody is cheating. And as I said a few times, many times in this panel before, the cases are becoming, in my specialty at least, more and more complex. So it's very difficult to make a real sort of what is true, what is not true, what is nearly true, what is nearly wrong. Again, it's less than ever yes or no. So the idea of being prepared, to me, perhaps is not a great idea, because it allows many, comment on dit, Alexandre, des biais, many ways to put a view which is, but which is a side view, which is not a big help. So to be completely honest and transparent, but perhaps it's because it's my culture also, I must say that. I think our approach is cleaner, I would say.
Mm-hmm. Thank you.
But it can be my culture and not the truth. That's why I was saying it's a very difficult question, I think. And by the way, I worked a lot on the blockchain phenomenon blockchain is going to be very difficult on that point too, because blockchain is a chain of people assuming that Mr. or Mrs. So-and-so, this or not this. And so preparing people is something which is going to be even more difficult to appreciate with the blockchain approach in the next years, perhaps.
Mm-hmm. Mm-hmm. So I don't see any more questions. So I have one general question. It's not a technology law.
If I may,
yes.
if there is no more question, Alexander, I would like to put another input, which is part of your question, I think.
Of course.
Everybody is speaking of artificial intelligence, working on that for years and years, and we had big discussions and open discussions, panel discussions with the judges. The AFDIT, the Association Française de Droit de l'Informatique, is interesting because we have many people of different approaches, lawyers, as you know, and you are a member, experts like myself, but also judges and different kind of judges, even judges from the Supreme Court, the French Supreme Court, which gives an open field to have open debates. And when you speak of artificial intelligence and of the use of artificial intelligence in perhaps automatic judgment, the question is, how can you be sure that it will be fair, impartial? And there are two ways to make it partial. The first one is to have an engine which is partial, to program a partial engine. And the other one is to have data, big data, which are themselves completely constructed to have a I'm back. It's okay. Well, perhaps that's part of the question too. If you prepare the engines or the data which are going to be used by the engine, you can prepare it. You'll have a partial answer. You won't be impartial. It's a bit the same than being prepared by the lawyers. That's why I wanted to put this additional point.
Thank you. So we have a question from Gary Benton. Hi, Gary, out there. The question is about documents being provided to experts. Do the experts review all the documents? Can they rely, do they get to see all of the documents that have been relied on by the parties? Should communications with counsel be deemed privileged vis-a-vis experts? What are the common law and civil law tensions on this? And does the obligation to produce expert documents differ between party appointed and panel appointed experts? Well, we had a dearth of questions just a moment ago, and now we seem to have many. So why don't I toss those questions of Gary out to our panel?
The question about privilege of expert counsel communications is a bit unfair, I think, because as far as I know, there is no internationally accepted rule on that. So the momentum seems to be in favour of saying that counsel and expert communication should not be disclosed. And people tend to work on that basis. I'm not aware of any, I've certainly not had any argument about the point yet, but it's kind of inevitable. And I know the ICC have been working on issues to do with ethics and international arbitration. This is one of those fields where, a bit like disclosure, people have legitimately different views depending on which legal tradition they come from. It'd be interesting to hear other people's views on it, but again, in the UK, we've had a debate about this, and in some limited circumstances, the communications between counsel and an expert can be disclosed, and indeed the expert is supposed to disclose the substance of the instructions, although that is usually managed by the lawyers so that the substance of the instructions are just to give their view on the particular case. in a sense, it shouldn't really matter what counsel is saying to the expert unless there is some suspicion that there is something unfair going on. But that brings us back to coaching. You know, is coaching unfair, an unfair advantage for a US lawyer, or just something that is in fact expected?
Just picking up Lawrence, I mean, I've always had the same experience as you in terms of I've always proceeded on the basis that exchanges between lawyer and appointed expert are privileged, and to date I've not had that challenged. Not that I want to be putting out any challenges to anybody at this particular time. The other thing I wanted to pick up on was in relation to documents and what should go to the expert, and I'm very much of the view that the expert should have sight of documents that are in the arbitration, whether they are relied upon by a party, or if they have been produced subsequent to a request for document production. My view is that material should all be put before an expert for him to make a decision to use for his benefit of his investigation. And I just wanted to sort of anecdotally raise one thing I've had in a technology arbitration, and that is we got an order from the tribunal in terms of document production to create a friendly committee where parties from each party had to send a representative effectively to sit in a room because the amount of documentation was huge. It got to the point where, you know, even if we put forward reasonable search terms for documents, the number of responsive documents were astronomical. So we got an order for a friendly committee for representatives from each firm effectively to sit in a room with a laptop each and linked up to their own document management system, and then to agree between them the search terms. And then once the search terms responded with a reasonable amount of documents, then that became the specific order for document production relating to that specific request. And I just, at the time, it was a daunting order, direct direction by the tribunal, but actually it really worked, because otherwise, I mean, this case had, you know, millions of documents, as is often the case with large IT projects. And it just meant that the parties could collaboratively agree something which was both reasonable and then actually met the type of document that the other side was seeking to receive. So I'd push that out as a terrifying procedural order from the tribunal, which actually ended up being quite helpful.
Great. Any other comments on Gary's question? Okay.
Not on
Yes.
Gary's question, but if I may, I would like to ask Eve and possibly the other members of the panel a question that relates with the following situation, actually a real life situation, that in which a technical expert, when preparing its expertise, is relying on a software. And that software in itself implies a number of choices in terms of its logic. And whether that logic is suitable or not to the case, and if that logic is the best one to answer to the questions of that specific arbitration matter, is a side story. So were you ever confronted with a situation in which you do have a technical expert, let's say delay analysis, for instance, and in construction, that's one situation, in which you have a number of softwares that you can use, and then a software expert to explain how the software is working, the one that it is actually applied by the technical expert in preparing its expertise. So have you ever encountered this chain of experts, and how did it work, or how you would suggest to do it in a better way? What can you tell us about?
I've had a case in which I wish that had happened, because the experts didn't actually know what they were doing. That they were experts in the particular field, and they were using analysis software, but they didn't really know how the analysis software worked. And in retrospect, that might have been quite a nice idea. And it's not necessarily to blame them, because they weren't experts in the particular software, they're experts in the underlying field. Yeah, I can see it cropping up where there have to be simulations run, or there have to be reconstructions, or there, or even there has to be development of code, which the experts may or may not be familiar with. But I've not personally had to have an expert come along and explain how the particular software the other experts were using worked.
Alina, we have started a discussion on that point. I've never been in a real case on your question, but we have started discussion on that point, and we're sure it's going to happen. And on the top of it, there is another aspect, which is if the software we're going to use legal in a certain country or not legal, which is another issue, but it's part of your question. But it's, I think it's really too sophisticated to be answered in a few words and in this presentation today. But I'm ready to open that for another panel, perhaps.
I have seen it happen with statistics, where say an expert in computer software comes along and will do a statistical analysis of bugs in the software and claim this is representative, because the expert is not an expert in statistics. And there has then been further expert evidence called as to why the first expert didn't know what he was talking about when he said this is a representative sample. And I think the experts do need to be quite careful not to step outside their expertise just because they happen to know about how computer programming works and what might be bugs in a particular software. Suddenly turning around and making assertions about a wholly different expert field, namely selection of representative populations of bugs, really was quite damaging for them. So that's similar, I guess.
So hopefully, Lawrence, we won't have to become all coders in order to vet and verify the programming of the experts who come to present evidence to our tribunals. But I think hopefully we can remain at the level of text and words and ideas. I had one case, I was on a panel involving a fire of a big factory, and it all burned down, no deaths, but part of the functioning of the factory was with hydraulic oil. So you can imagine that the oil burned as well and helped to consume the building. And we had competing expert reenactments, all digital. And each reenactment included a lot of assumptions about the starting temperature, the wind direction, the flammability of the building materials, the speed of the flames, progression of the flames, and because the two simulations were so different, we started to dig into all of those assumptions, not into the code. It's a little bit similar. We didn't have to go into a code or a program, but we said to the parties and the experts, these are so different, each one looking so real, isn't it? Because when good professionals have the good video reenactment tools, it all looks so lifelike. But we had two sets of reenactments with two very different results. And so we basically dismissed relying on the visuals that were provided by the reenactments, and simply asked and drilled down into the assumptions that the parties had used about all that went into the making of those visuals. And we got the results that we wanted. Sometimes programs, visuals, all these extra aids can get into the way, in the way more than actually help. At least that's been some of my experience.
But Alexander, it's a real case. I'll try to make it very short, but when we are looking for elements on a disk or on a cell phone, we're using softwares which we know the software, but we don't know at all how they are built. And it's very common that one software, I'm not going to give names, when you're in this process, is finding email you are looking with a certain characteristic when the other one find them. And it all depends on the ability of the expert, but also on the quality of the software. And by the way, these software are not French. So judges say, are you sure? No, Mr. Judge, we are not sure. And they don't like it, but it's true. So it's already something which happens.
Let's see. Well, I think that's it. That's all for the questions. Unless the panelists have other questions, it looks like my job as an MC is coming to its close. I'd like to thank all of the participants, and maybe I can turn the floor back to Les, who opened our session, and he can have a closing word. Thank you all.
Well, thank you, Alex. I must say, I opened with the thought that our Paris Arbitration Week programs have been spectacular. And I must say, I think today's program was actually one of the best programs that Silicon Valley has partnered to put on. The subject matter, Stan and Congruta, that you covered, and Alex, your stewardship was just excellent. And I think there were so many practice tips that actually came out of the program today in dealing with expert witnesses. I found some tips to adopt, and as an advocate, I always thought you wanted to have the best expert who was the most articulate, had the best cachet, and could lead the panel through to the conclusion you wanted. Sitting in the chair of an arbitrator, I often find, I'll be quite honest, myself muddled between expert witnesses, even after some questioning to them, and using techniques like Paul mentioned, hot tubbing, of deciding which way to go. And I don't think I'm singular in that. I think most arbitrators find themselves in the same way with competing technology in high stakes cases. So there were some lessons learned for me here, and I thank you very much. It was very, very good.
Wonderful. Well, thank you, Les. Thank you to the SVAMC. Thank you, Les, for continuing to support these Paris Arbitration Week conferences. And thank you to AFDIT. I don't think he is on the phone, on the Zoom anymore. André Meassou, who is the president of the AFDIT here in France, was very excited about this program and was very supportive, and Yves as well from the AFDIT. So with that, and with the reminder that we are in Paris, I can say au revoir, and thank you very much.